Hello and welcome. Thank you for joining us. My name is David Enterline. I'm a U.S. immigration lawyer, and I specialize in the EB-5 immigrant investor visa. I've lived and worked in Asia for over 20 years. Today we're going to talk about the new EB-5 Reform and Integrity Act of 2022. This is a comprehensive law that was passed by Congress this year in March 2022. Now, there are many changes to the EB-5 program based on this act. We don't have time to talk about all changes, but we are going to focus on what I think may be most important for you, the interested investor that's interested in the EB-5 program to immigrate to the United States. As mentioned, I've lived and worked in Asia since 1993, so almost 30 years. And I'm an active member of the American Immigration Lawyers Association and the AILA Asia Pacific District Chapter, which is an organization of 15,000 strong immigration lawyers from the United States. So today we will talk about the EB-5 Reform and Integrity Act of 2022. This is a new act passed by Congress on March 15, 2022, and most of the provisions go into effect on May 15, 2022. The two most important points of the act are what we call grandfathering of existing EB-5 investors and the reauthorization of the Regional Center Program. We'll talk about these in more detail going forward. So as a reminder, the basic requirements for EB-5 have not changed, except in this case the investment amounts have been increased from US $800,000 if the investment is made in the targeted employment area, or US $1,050,000 for an investment made that is not in a targeted employment area. The investment must be made in a new commercial enterprise. The investment, we must be able to show, creates at least 10 jobs for U.S. workers, and the investor is somehow involved in the management of the business. Involvement of the management of the business does not mean that you need to be involved in the day-to-day management, but that you are a partner or a member of a limited liability company and have some overall authority for the direction of the business. A few definitions and abbreviations that I will use in the presentation. Well, first, I will refer to the act as the act going forward, so that will shorten the title. The Regional Center, we will abbreviate as RC. The Regional Center allows investors to count direct and indirect job creation based on their investment. New commercial enterprise. This is the company or partnership into which an EB-5 investor will make the investment. In most cases, the new commercial enterprise will serve as a funding vehicle, much like a bank, that will loan money to the job-creating entity, or the project we often refer to as. And the project is the company that receives the investment and uses the money to create jobs. Through a loan typically, and at the end of the loan period, which is often 5 years or longer, then the JCE can return the loan back to the NCE, and as long as investors have completed their EB-5 process, they could receive back their investment capital. So I mentioned targeted employment area. The rules for targeted employment area have changed a little bit. The first targeted employment area is a rural area. The rural area maintains the same definition as before. It is an area of low population. So in a city of less than 20,000 population or in the countryside, then a rural area can qualify as a targeted employment area. And again, this means an investment of only $800,000 US. Another targeted employment area is what's called a high unemployment area. This is an area with 150% of the national unemployment rate. So this could be an area within a large city, but in which there is high unemployment, and the U.S. government wants to encourage investment in those areas to create jobs. Now, one change from the act is that high unemployment areas now are determined only by USCIS, the U.S. Immigration Service. And the third and new area for targeted employment area are what we call infrastructure projects. And these are projects that are administered by a government entity that is contracting for EB-5 financing to help with the development of the project. Now, most important for existing investors is the grandfathering clauses. This preserves the eligibility for all past investors who already made an investment in the EB-5 program and can now continue forward. So a little bit of history. The Regional Center program expired on June 30th, 2021, and for about 9 months, those EB-5 investors who had previously invested were not able to move forward in the process because the law for regional centers had lapsed. The new act now allows those investors to move forward. So any investor who filed an I-526 petition in the past can now continue with their immigration processing. This is very important for the integrity of the EB-5 program for future investors that are considering it. Another important addition to the EB-5 program based on the Act is adjustment of status ability. The adjustment of status is when a person in the United States as a non-immigrant or in non-immigrant visa status, such as a student on an F-1 visa or a temporary worker on an H-1B visa, and there are many other non-immigrant visa categories. They may now concurrently file a Form I-526 petition along with a Form I-485 adjustment of status application to adjust their status in the U.S. Adjustment means moving from a non-immigrant visa category to permanent residence, immigrant visa category being EB-5 in this case, and obtaining permanent residence without having to leave the country to go to a U.S. consulate and interview for an immigrant visa. So this new law allows the EB-5 investors who are eligible in the U.S. to file the Form 485 at the same time and remain in the U.S. throughout the process. That's waiting for the I-526 petition to be approved and staying in the U.S. to adjust. Investors and family must legally be in the U.S. and visa numbers must be available at the time of filing. This means that moving forward, some countries that have a large demand for EB-5 visas and are subject to a waiting list on the Department of State visa bulletin may not be eligible. And these countries historically were China, India, and Vietnam. Now, in the next few months, the visa bulletin categories have been current and may be current for a month or two, but they will become subject to wait lists again. So persons from those countries may lose their eligibility to adjust, to file the I-485 adjustment of status application. Reserved visas. This is something totally new in the Act. There are certain types of visas that will be reserved for new investors. 20% of the 10,000 visa quota will be reserved for investments made in rural areas. 10% will be reserved for investors in high unemployment areas, and 2% will be reserved for investors in infrastructure programs. That's a total of 32% of visas that will be reserved for new investors. What this means is that investors that invest now in one of these areas may be able to jump in front of the line waiting for visas. That means this is really only going to be beneficial for countries that have oversubscribed for the number of visas needed, which I mentioned before were Chinese, Indian, and Vietnamese investors. Unfortunately for past investors, these small percentage of investors may be able to jump ahead of those that have been waiting a long time. For countries in which visas are not oversubscribed, which is basically the rest of the world, this will have limited benefit to those investors who don't have to wait for visas now. Another important new provision of the Act is a longer-term extension of the Regional Center program. Now, the Regional Center Program, which was originally enacted in 1993, had always been a temporary program, and for years had always required extension. First, it was every 5 years, and then it became every year, and then even multiple times per year. So this created much uncertainty in the EB-5 program. The Act now extends the program through September 30, 2027, so that investors who invest now can be assured that, the program will not expire for 5 years. And more importantly, any investors that file the I-526 petition before September 30, 2026, they'll survive termination, and the investor remains eligible to move through the program. So even if the Regional Center Program is not extended after September 30, 2027, those investors that comply and file before September 30, 2026 can still continue forward even if the program expires. Some of the requirements under the new Act are focused on regional center compliance. In order for a regional center now to accept investors so that the investors can file the I-526 petitions, the regional center must first file an application for a target project before petitions can be approved. Now, the application does not have to be approved before investors can file the I-526 petitions. We just must show that the regional center has made the application. Projects that are accepting investors must disclose all fees that may be paid to marketing agents and brokers. The regional centers and projects must meet stricter securities law compliance rules. And the USCIS, the Immigration Service, must perform a site visit to each project, giving them at least 24 hours notice. Now, regional center obligations to protect investors. These are provisions that have been provided in the Act, most of which are for the protection of investors. For example, the regional centers must keep records and undergo Immigration Service audit every 5 years. And as I mentioned a moment ago, there are much stronger securities laws and other legal compliances that are required by our regional centers. Additionally, there are codified penalties for misstatements or noncompliance, including regional center suspension, potentially fines of up to 10% of capital raised, debarment of individuals that may be involved in the regional center, and even termination of the regional center and program eligibility if they're found in violation of the rules. Continuing on with additional protections, regional centers must disclose all marketing fees that are paid in the course of its marketing and sales. Regional centers must share relevant parts of the annual financial statements with investors, giving them more insight into what is the financial status of the regional center and the projects. Only citizens, U.S. citizens and permanent residents may be involved with a regional center. And then people with criminal records or other financial violations cannot be involved with the regional center. Now, fund administration is one of the core changes. This is, again, to protect investors. As mentioned, regional centers and projects must share financial statements with investors. New commercial enterprises must maintain EB-5 capital in insured separate accounts, or they must retain a third-party fund administrator to ensure capital flows to the job-creating entity. There are some provisions in the Act that we call innocent investor protection. This protection for investors who suffer a termination of their regional center or their new commercial enterprise or some failure in their job-creating entity, which is the project. Within 180 days of any adverse action or notice of any adverse circumstance, investors can associate with replacement entities. So they may associate with a new regional center, or they may make an association with a new NCE or JCE without losing their priority date, which is their place in line for a visa and their children can continue to stay protected from aging out, which is turning 21 and being ineligible to receive their visas. Now, it's important to note that it may require an additional investment in order to continue to stay qualified and be protected by these provisions. So if, for example, the money was not used correctly, the investment may not be able to be returned, and therefore an investor who wants to take advantage of these protections might have to make a new investment into a new NCE under a new regional center. But this does provide some additional protection to investors. Now, under the Act, promoters of the EB-5 program, typically immigration agents, migration agents, immigration consultants, or brokers, are also to be governed under the Act, and such promoters must register with Immigration Service, pass background checks, follow Immigration Service guidelines for immigration and security compliance, have written agreements with the regional centers and projects, and must fully disclose all fees to investors in writing that will be filed with the EB-5 petitions. This is to make very transparent the promotion process and all fees that are being paid out for these finders for the benefit of investors. Thank you for joining us and staying through the whole presentation. As I mentioned at the beginning, there are many changes based on the Act, and we only had time to cover what I feel are the most important for you if you're interested in the EB-5 program. Overall, the Act has made investing through EB-5 a much safer opportunity for you, potential investors, to immigrate to the United States. And if you're considering it, I encourage you to contact us for more information.